Okay, so good afternoon. Today I've asked Immigration Minister Nathan Guy to join me in making an announcement about our immigration policy, in particular around potential mass arrivals of illegal immigrants and people smuggling. So we'll run through the details of that, take any questions before covering off any other my ministerial activity and any other questions you might have. So today I'm pleased to announce the government will be introducing tough new measures to deter potential mass arrivals of illegal immigrants and people smuggling to New Zealand. These new measures are designed to make it easier for officials to better manage any mass immigration arrival that may reach our shores by any means, including boats. An amendment to the Immigration Act will be introduced to Parliament this week to enable a mass arrival of illegal immigrants to be detained under a group warrant, rather than under individual warrants, as currently happens with asylum seekers. This is because a mass arrival group would likely include people whose identities are unknown or are in doubt, and who may have criminal backgrounds or connections with criminal or terrorist groups, and could pose a security risk for New Zealand. Moving to a group warrant will enable our immigration officials to focus on managing immediate risks rather than being tied up in paperwork and clogging up the courts trying to obtain individual warrants. The second measure we are introducing is changing supporting policy requirements to make it necessary for a claimant's refugee status to be reassessed 3 years after it is determined. This means asylum seekers would only be eligible to be granted permanent residence after successful reassessment of their claim. The final major change we are introducing is limiting family reunification for mass arrivals. This means those mass arrivals that, after due process, may be accorded refugee status and granted permanent residence will be able to sponsor immediate families such as their spouse or children to join them in New Zealand. Extended families, such as parents of an adult refugee and adult siblings, will not be eligible to be sponsored. The policy changes will only apply to illegal mass arrivals. They will not apply to those refugees who go through the normal and proper application processes, for example via the UN High Commissioner for Refugees. The changes will come into effect when legislation is passed. It's our intention for the legislation to go through the House this year. Not only are we introducing tougher new policy, but tomorrow officials will begin a major exercise called Exercise Barrier to test preparations for a mass arrival of asylum seekers by boat. This exercise, which has been in planning for more than 12 months, will take place over the next 8 weeks and will involve officials from up to 17 government agencies under the lead of New Zealand Customs and Immigration New Zealand. It will involve 3 1- to 2 day planning exercises, include a live exercise when a simulated mass arrival occurs, which will be processed at Devonport's Naval Base in Auckland in late June. New Zealand has not yet had a mass arrival of illegal immigrants reach our shores, but our isolation does not make us immune from such a risk. In 2010, a group of close to 500 illegal immigrants from Southeast Asia landed on the west coast of Canada after a journey of nearly 13,000 kilometres. And as we know, mass arrivals are a major issue for Australia. The recent events in Darwin, where a group of 10 Chinese nationals claimed asylum in Australia but had hoped to make it to New Zealand, further affirms that it may just be a matter of time before a boat of people seeking asylum try to come to New Zealand or may even get here. New Zealand needs measures to properly address and mitigate this risk. We want to send a clear message to potential people smugglers that we are not an easy target for people smugglers and their customers. And any attempt to migrate illegally to New Zealand by sea would be an extremely dangerous and treacherous venture that will put the lives of those involved at great risk. We want to discourage anyone from taking that risk. There are appropriate channels for genuine refugees to use. These measures are about dissuading people from trying to jump the queue and breaking New Zealand's immigration laws. The government is clear that sort of behaviour will not be rewarded, and that people smugglers will face the full force of the law in New Zealand. These measures are not about punishing people who have a genuine claim for refugee status. New Zealand will continue to offer protection to those with valid claims It is about dissuading people from risking their lives and not rewarding the illegal behaviour of people smugglers. New Zealand remains committed to fulfilling its international good citizen obligations by accepting an annual quota of up to 750 UNHCR mandated refugees. I'm now going to hand over to the Minister to say a few words, and we'll take any questions and we'll go back to normal business.
Thanks very much, Prime Minister. I'd like to reinforce what the Prime Minister has said today, that this sends a strong message that New Zealand is not a soft touch. We want to prevent people smuggling, ventures that are indeed thinking about coming to New Zealand, and we saw that recently with 10 Chinese that ended up in Darwin. We want to make it not desirable, and we don't want to reward these people for attempting to come to New Zealand. The Prime Minister's also talked about the near 500 that made the large journey across to Canada. We're very mindful of the fact that we need to be aware that in the future there could be such an operation down to New Zealand. Queue jumpers should not be able to push in front of genuine, needy refugees. New Zealand remains committed to fulfilling its international good citizen obligations by accepting refugees, and our current quota is around 750. The legislation being introduced this week has a range of measures to deter future attempts and better manage these attempts if indeed they do occur at any time in the future. Overall, this is a very firm but fair package in my opinion. The advice that I have received is that it complies with the Bill of Rights and our international obligations. This will bring us more in line with the current Australian approach, with a mass arrival able to be detained under a group warrant. I also note that Canada is considering something similar with their legislation at the moment. In terms of timing, the Immigration Amendment Bill that has been introduced today, I expect it to have its first reading in the Parliament this week, and we hope to have this passed by the end of the year. Open to any questions.
Why family reunification restrictions for mass arrivals rather than, why restrict family reunification just for mass arrivals rather than other asylum seekers as well?
Yes, well currently some do come in and seek asylum off the plane, and they are in very small numbers. But if you look at the example of Canada, where 500 could come in to somewhere like New Zealand, indeed that would swamp our organisation, and also we want to send a very strong message that it's not appropriate for large numbers of people to queue jump and come to New Zealand, and if they work through the process to indeed be able to bring their immediate family in. So this change will mean that they will need to go through a process, they will be reviewed after 3 years, and then they will have the opportunity to bring their immediate family in if they've worked through that process, but they won't be able to bring any extended family members in.
But what about someone arriving illegally by themselves? I mean, shouldn't the same thing apply to them? That if you haven't gone through the process, you shouldn't be able to bring in an extended family after 3 years?
Well, there are some that do come in on the plane with indeed all of their passports and visas intact, and then they do claim asylum. We have about 300 of those per year, but you need to know that about a quarter of those, so about 70-75, are indeed only processed. So there's a very rigorous process for those to go through. This is all about sending a very strong message to those that are contemplating getting on a steel-hulled vessel like the one that went to Canada that was extremely well organised, that those people aren't welcome here because they are going to be detained.
So it's the message that you're welcome here, well, you know, I mean, if you're coming in by yourself, I suppose, just for a matter of consistency, you're saying that people who come through illegal means and try to come here illegally shouldn't be able to have extended family, but it's not always going to be in a mass arrival.
No, but there's the fundamental difference is if someone comes on a boat as part of a mass arrival, been part of generally an organised scheme which has people who run the business of doing that. We're trying to send a message not just to the people who claim asylum, but actually to the people smugglers, that that is a business that they shouldn't be in. They're not welcome in New Zealand. The rules are different.
Would genuine political refugees who are claiming asylum, who come on such a boat, be precluded from claiming asylum if they reach here, even if they are travelling as part of a group of the sort you described?
Well, we'd have to work through that process, sir. Obviously, there is a process if a vessel does get to our shore for these people to go through, and then we would have to decide on the level of detainment, whether it was open or more of a secure slight detainment. So I prefer not to get into the individual aspects of this. This is all about sending a very strong message for those that are organising people smuggling, that are choosing potentially in the future to come to New Zealand, that we aren't a soft touch.
But from what you're saying, someone who was wanting to lodge a political persecution claim for asylum would not be precluded from doing so, even if they arrived in such a group, from what you're saying?
That could be the case, sir.
Do you have any intelligence of an imminent mass arrival that's prompted this urgency to produce this bill?
Well, we've worked on this for a long period of time. There's been a lot of consultation with the 17 agencies that are involved in the simulation model that the Prime Minister's talked about over the last couple of months. We share intelligence all around the world. We are aware of the big steel hull vessel that went to Canada. We're also aware just a few weeks ago of the 10 Chinese that ended up in Darwin that were indicating they wish to come to New Zealand. So this is all about sending a strong message that there is a process, and that is to go through the UNHCR process where we take up to 750 refugees. That's where...
But you don't have any intelligence that the boat's on the way?
There's no particular intelligence as of today. I think the way to characterise it is we don't see this issue as hypothetical, and so from that you can assume that we've seen intelligence in the past of missions that either weren't successful or were at the border stopped from leaving. So we believe that's a credible risk that New Zealand faces. That's why the government's
You used the Canadian example. If we did have a mass arrival like that, or of any size, where would we detain all of these people?
So if we did have a large number, like nearly up to 500 that occurred in Canada, we would look to process them at a place like Devonport. We would take some time. That's why we need to go through the detention process in a group, which is up to 6 months. We would look to then work out those that were a security risk, those that may have some health issues. If indeed they did have high-level security risk, we would look to locate them in somewhere like a prison. Those that had lesser risk, we would look for an open detention facility, which could be somewhere like a Mangere or indeed a army base.
So the so-called boat people in Australia become a political football there. I mean, is there a danger that will happen here? I mean, the language about soft touch is the sort of the political language that you hear in Australia as well, in terms of the sort of political debate about the issue.
Well, I don't think we make any secret. We do not want to welcome people into New Zealand on a mass arrival basis. To do so, they're firstly jumping the queue, and New Zealand plays its part in terms of taking genuine refugees through the UNHCR program. Secondly, and I think importantly, we are trying to send a very strong message to those that organise these activities that we're not going to be an easy target for them. And I think both those messages are important. So yes, there's a degree of sending a strong message here, but I think for good reason. I think over time, as these boats get larger, as their capability gets greater, inevitably this is going to be an issue New Zealand faces, and we want to be ahead of the curve as much as we can be.
Has the government considered dedicated detention centres as in Australia?
No.
This package of changes you've announced, are they only aimed at boat people? So in terms of making it, having to reapply for status after 3 years, etc., is all this only aimed at people who come in on boats, or is this for all refugees?
This is aimed specifically at a mass arrival, and in the legislation we're saying that's any more than 11.
In terms of the family reunification thing and stuff, What would happen if we took, like the task force, if we took boat people that have arrived in other countries and we took some of them as our refugees?
I think that would be a different scenario because under Tampa we actually negotiated and agreed to take them into New Zealand. They were technically an illegal mass arrival. They were part of an agreed negotiation with the Australian government, so it's a very different deal. So it would depend if they came in, as I say, as an illegal mass immigration, they'd be subject to these rules. But if we did a deal with another country because we chose to do that, then no, they wouldn't be subject to those rules.
Just to clarify the language with respect to queue jumping that's been mentioned, is it the government's understanding that there is no queue when it comes to political asylum claimants? Because such people don't have a queue.
I don't think
they have under the Refugee Convention the right to claim regardless.
We're looking at a particular category in which they might seek asylum. The view of the government is that the way that we take those that want to form part of that overall refugee category is that there's a process for doing that, and that's through the UN. And there might be a variety of reasons why within that they claim asylum in New Zealand, but we take them through that category and preferably that category alone.
Yeah, and you're not assuming that people who claim asylum are in some way jumping a queue because they would prejudice their rights under the Refugee Convention.
Correct. Okay, we'll move on to other issues. So tomorrow I'll be at caucus and question time. I give my pre-budget speech at lunchtime, midday. The advisory will be issued shortly about this event on Wednesday and Thursday in Wellington. Friday I'm in Auckland at various events. The House this week will include the Appropriation 2010-11 Financial Review Bill, the Taxation International Investment and Remedial Matters Bill, and the Crown Pastoral Land Rent for Pastoral Leases. On Wednesday we have the Budget Policy Statement made.
When you called for Winston Peters to be stood down plenty of times over the OMBM donations,
Yep.
why is your standard lower now?
Well, I wouldn't accept that it is. In the case of Mr. Banks, what you have is a situation where there are some claims by individuals. There's a very strong refuting of those claims by Mr. Banks. My office has sought an assurance from him that he believes he's fully complied with the Local Government Act. He's given me that assurance. He's issued a statement to exactly the same effects. It's different from the situation with Mr. Peters, where in the end there was clear evidence being supported that he was in breach. Took quite a period of time, and he was up before the Privileges Committee.
Have you asked him if he knew where those donations were coming from? Or knew they were coming from?
I haven't directly spoken to John Banks, but my office has. What we haven't done is a forensic analysis, because I think it's important to understand what the test is. The test is, does a minister enjoy my confidence? And they will, if I can believe and accept their word. He's given us a categorical assurance that he believes he has complied with the Local Government Act.
But isn't there a moral obligation there that if he knew where these came from, that he should be upfront about it, especially with you?
Well, the very clear obligation is to follow the law. So as long as he has followed the law, then he has followed all of the requirements when he signed his claim as the Mayor. Now, that's a matter for him, but he's given me an assurance that he has.
Why have you not spoken to him yourself?
Well, there's no real need to. I mean, when my office speaks to him, they speak on my behalf, and that's good enough. It's taken as directly speaking to me.
So you're saying that if there's been any behaviour, for example, asking Dotcom or anyone to split up cheques, or that if it's still not actually illegal, then you're happy with that. So it's only if he's actually broken the law. If there's any behaviour that might be a bit grey, that's okay.
Well, you can't and I wouldn't sack a minister for complying with the law. So the test is, has he complied with the law? As a number of academics and lawyers have pointed out in the weekend, the law as it pertains to local government is vastly different now to the law that pertains to central government, and that's because of the changes that were made some years ago. So the test is, did he breach the law or not? If he hasn't, then he's not guilty.
Well, would you sack a minister for lying? Would you sack a minister for lying? Do you find it credible that he in a press release says he has no idea where this 50,000 came from?
Yes, because that's eminently possible in terms of the way that the disclosure regime works under local government law.
Do you accept that the local government law is much more lax than what it is when it applies to central government?
I do, and that could be a matter for genuine review. I think if you go and look at what's happened, there's a significantly different disclosure regime under central government and a significantly different requirement on political parties. But the facts of life are that the return you're talking about was subject to the local government law, and as long as he has complied with that, then I don't think you realistically argue the case that you should be sacking a minister for complying with the law of the day.
So do you think they should be more consistent with the electoral law obligations for general elections?
Well, my instincts are that the changes that are made are probably to the betterment of transparency and the overall democratic process, and there could well be an argument that says that local government disclosure regime should also change, but that's obviously subject for another day.
But wouldn't it be wiser to stand them down while there's investigation and then reinstate them? Because if you use Mr. Peters' case, well, he was never found breaching, it was a breach of law. I mean, he was investigated by the police, serious fraud, and they did the way target.
Yeah, well, I mean, if I was to stand down every minister that was subject to a claim by the opposition, then I'd be subject to stand down lots of ministers. So I don't think that's the right test. In the end, the test is whether I believe I can accept their word, and I've got no reason not to do that. It's been very clear. The questions haven't been ambiguous. They've been extremely clear in this defence.
But isn't the police investigation, isn't that a matter that actually ups it further than just an allegation from an opposition MP?
Well, there would be a vastly different proposition between being charged by the police. I mean, it's subject to anyone can go to the police and lay a complaint, and the police are duty bound to investigate that complaint. But that doesn't mean, and again, that wouldn't be a satisfactory test, because again, any politician or interested party could do that.
So
that's not the right test.
If charges were laid, would you
That's a different
reconsider?
story.
That would be, so you would at that point consider standing him down if the police proceed any further.
Well, that's for another day, but I think you're a long way ahead.
But again, Winston Peters was investigated, he
Yeah.
stood down and he was never charged.
Yeah.
So I mean, and you say you are adopting a higher standard than the previous government.
Well, that would be my view.
Well, but what?
Well, what you've got is a situation that's quite clear. One party's made some claims, the other party has utterly refuted them.
Has he?
And I'm not there to arbitrate between them. That's not my job. That's a matter for the police. And Trevor Miller, as I understand, has taken that matter to the police. It's for them to arbitrate on that.
Has Mr. Banks actually utterly refuted them? Because most of it he says he can't recall. He does refute thanking him by phone. But apart from that, he says he doesn't remember any of the conversations. That's quite different to utterly refuting him.
Well, no, I think if you look at his statement, it seems pretty clear to me.
He says he didn't phone him and thank him for the donation.
Well, which bits would you claim is in breach of the Local Government Act that he hasn't refuted?
But he knows it's anonymous, even though
Well, he
he's saying
hasn't,
there's a
he
credible
hasn't
argument.
refuted the conversation that Dotcom talked about with the 2 or 3 people in the room discussing the 50,000 donation and splitting up into 2 cheques. He said when he was asked about it quite
Well,
often,
you need
he
to raise,
couldn't remember.
yeah, you need to raise those matters with him. But my only point would be, of itself, that wouldn't necessarily mean that someone's in breach of the Local Government Act. I suspect, I don't know, but you need to check that. And in the end, the onus is on the minister. He's been very clear and direct with me.
Do you have a concern that even if the black and white letter of the law hasn't been broken, that the spirit of the law may have been thwarted?
Well, I wouldn't want to speculate on some hypothetical sort of examples. What I'd say is that, what I said earlier, that is there may be a genuine case for looking at changing the law, because the law may be in fact very loose. I suspect it is, if it's anything like the previous regime that applied for central government, so that might be a genuine case. But again, it's the responsibility of individuals and ministers to comply with the law, and you can't have a hanging offence for complying with the law.
But that seems to be the way that you and Mr. Banks, if you like, are getting around it, because the law is so loose, he can't have broken it. And again, it comes back to the issue that you've raised many times around the standard of conduct of ministers, which must get down to their ethical conduct, not just their lawful conduct. And are you happy?
Well, I haven't seen anything that would indicate that he's in breach of the law. At the end of the day, if the law is that you drive at 100 kilometres an hour without excess of 0.08 in your blood alcohol levels, that's the law. Yeah, you're in breach of the law.
The analogy here is that disclosure rules exist so that people will know where donations come from and how much they were. In this case, if the law is lax enough to allow that to be shielded under anonymity. This is why I raised the point about whether the spirit of the law, if you found that a minister had colluded to thwart the spirit of the law, would that be a matter where you would feel that perhaps was a hanging offence?
No.
This morning you said your test was you had to believe him, you
Yeah.
had to believe John Banks. How can you believe him if he can't remember some of it?
Well, because he's put out a very clear statement. He's given my office a categorical assurance that when he signed his return in local government for that election back in where it was 2009, 2010, that he was fully compliant with the law. That's the question we've asked him. The allegation is that he's not, and he's refuted that situation that he's in breach of the law.
As part of that then, did he check his phone records to see whether he had phoned Dotcom? Because is it strange though that he can't remember any of the other conversations, but the one thing we can remember with absolute clarity is that he didn't thank him, call him to thank him. And that's the one bit that might hang him, isn't it? That's the one bit that says it wasn't anonymous.
Well, there are questions that you need to pose to him. Again, it's not my job to do a forensic analysis because I don't do a forensic analysis on lots of discussions I have with ministers. In the end, they either enjoy my confidence or they don't. And they'll continue to enjoy my confidence as long as they don't mislead me. We've asked direct questions. Those direct questions have been answered. I can't tell you whether he's made phone calls or not. I also couldn't tell you what's in those phone calls. He seems to indicate in his statement that he's not denying he's had a phone conversation, but he's made it clear in his statement that that phone conversation wasn't to thank Dotcom for a donation to his mayoral campaign. I can only accept the minister as word.
In answer to Gordon's question before, you seem to suggest that if Dotcom's account of that meeting where the cheques were discussed is correct, you don't have a problem with that. But someone who's going to receive a donation can advise the other, maybe even request the other party to make that donation in a particular way to make it anonymous. But isn't that turning the intent of the law on its head? I mean, well, that's not what anonymity was for, is it? It's to protect the public so that they know who's doing these things if the individual knows they're getting the money.
Yeah, so I'm respecting that I'm not a legal expert. My understanding of the local government law is that it doesn't preclude the sorts of discussions you're having. Now, that may make the law not very well designed, but nevertheless, that is the law, and it's the responsibility of people to comply with the law. People don't decide they don't like the law, as I said earlier, may well be that there's a genuine case for changing it, as Parliament did in relation to central government. That's a legitimate case. But at the end of the day, all of us as citizens are expected to comply with the law. And there are lots of examples where people have discussions about things. It doesn't mean that necessarily follows. We'll be having lots of discussions with countries around the world about whether they'll be supporting us for our UN Security Council bid. I can tell you now, lots of them to our face have told us that they have. It doesn't mean that's the way they'll cast their vote.
I'm not a lawyer either, but when you look at the...
But it makes two of us.
When you look at the law and its likely intent, I mean, if you have a law that says anonymous donations presumably must be genuinely anonymous, surely there's a reason for that? What's your interpretation of the reason for that?
Well, I'm not a lawyer, and I don't think from memory, around when Parliament passed that, so that's not the test I'll be applying.
Isn't it to ensure that the public knows who's making large donations if the person who receives them knows?
Yeah, so you're making a number of assumptions, and all I can say is that the responsibility of the minister is to comply with the law, because the allegations against him is that he's contravened the law, and there is a big difference there. So if he's complied with the law, some people might not like it, but he's complied with the law, and you wouldn't sack a minister for complying with the law.
So what you're telling us, you're happy with the minister to act unethically as long as they act lawfully?
Well, the test is because there's quite a wide definition of ethics. So the test is, and I'm not subject to those discussions that may or may not have taken place. So the test I have to apply is the law.
But he seems to be saying, if Dotcom's description of events is right, he seems to have been saying to Dotcom, please give it me in this way so the public don't know.
Well, I'm not going to go into that because I'm just simply not subject to it and haven't had those discussions to suggest you direct those at Mr. Banks.
He's not answering any further questions until the police inquiry is over, so it's a bit difficult.
Can you give us an update on the negotiations with Sky City?
No progress on last week, to be honest.
So no news is good news or bad news?
Well, it's good news because it means that the negotiations are ongoing. It's bad news in the sense that it means we haven't yet concluded the deal, but I'd like to.
You've said in previous press conferences that you would expect the conference centre to draw 200,000 bed nights, I think you said.
Something like that.
Whose analysis is that, and what does that imply in terms of the number of conferences?
Yeah, I don't know the answer. I'd have to go and check my office about to give that to you, but it will have come from one of the briefings we've had, either the feasibility study or MED, but if you want to direct it to my office, I can get you the answer.
Can I just ask you about the ACC tapes? And you seem to be suggesting this morning that you might be dubious about whether, or the veracity of the recording of that meeting?
No, what I'm saying is, I haven't seen a transcript and I haven't looked at the tapes. I was vaguely aware that there may be the existence of a tape. What the transcript may be absolutely right and in its totality, I don't know. I'm not in a position to judge that, but it's before the police and they certainly can.
Did ACC bring it to either the Minister or the Government's attention that that tape existed?
They may have to the ACC Minister, although I haven't had that conversation with her, but that's not the source I heard it from.
And from what you saw of the transcript then, do you think that a potential crime had been committed?
I haven't seen the transcript, I've literally seen the report in the Dominion Post today. I wouldn't want to comment on that because it would depend on what other material, what other discussions, what other things have gone on.
So has any further explanation been sought from the ACC chairman or chief executive today?
I'm not aware of the Minister doing that. I think the position she's adopting is she's leaving with the police to work through the investigation.
And just the other thing I was wanting to ask you about was, I think there was a community meeting yesterday in Christchurch where the government came into a bit of a flack about being a sort of fair weather friend and not doing enough. I mean, what's the response to that?
Look, I think it's Leanne Dalziel largely getting the facts wrong and playing politics, unfortunately, with the emotions in Christchurch. As I understand it, there are basically two parts to the claim, really. So, in the case of option 2, if the EQC land settlement exceeded the rateable value, the Crown would pay the former landowner the difference. Would not pocket it, as Ms Dalziel is suggesting. So that's the first thing. She's quite wrong. In the case of option 1, I think that is a possible scenario where the EQC valuation is different, as in substantially higher, I think is the argument there. But the advice I've had is that it's very, very, very unlikely. So there are very few cases like that.
So have there been any raised with you or the government?
Not with me directly.
Yeah.
Again, it's possible through the Minister's office. You need to check.
We'll see tomorrow in your speech some of the ways you'll make up this $600 million.
Well, funny enough, we're having that discussion right at the moment, so like a lot of speeches, they can change right to the last minute, but yeah, you'll get a bit of a sense of where we're going. Look, the simple bottom line is that we are going to get back to surplus by 2014-15 if it's within our power to do so, so that's the government objective. The Minister of Finance pointed out last week the challenge that's been set for us, but it's got a bit harder, but we remain committed to doing that. I think the important point to understand is that while that makes the challenge more difficult, I don't think people should think that this budget is going to be a slash and burn exercise. There'll be some changes in there, and they'll have some implications for some New Zealanders, but overall I think the balance is about right, which is it will provide, I think, economic certainty for the country that we are on track to get back into surplus, and it will be fair in terms of the allocation of resources.
You said this morning that it wasn't just going to be spending cuts, there were going to be some rearrangements.
Correct.
So what kind of rearrangements are you looking at, and will it be sort of holding policies back a year or two? Will it be on those lines?
Well, I'm not going to detail the individual component parts of that tomorrow. I may have a little bit more about broadly some of that to say tomorrow, but I may not as well, so let you know about 1 o'clock. Okay, thanks very much.